Hello, I'm Ted Leverette, the original business buyer advocate. For more than 30 years, I've been helping people find and buy the right businesses the right way. I'm not a business broker. I don't sell businesses. Most of my presentations are aimed at people searching for and buying businesses. Business brokers, owners, sellers, advisors, they tune in also because they want to find out how the best informed buyers are going to act and think. What you're going to hear today is for everyone. If you're thinking about buying or selling a small or mid-sized business, you're going to hear attorney Scott Weavil. He's going to concentrate our attention on some of the most important and risky aspects of deal making, reps and warranties. Now, before I turn it over to Scott, Weavil, W-E-A-V-I-L. Okay, one of the things I hear a lot from people who follow me is most legal documents, they have too much jargon and they're just too damn hard to understand. Scott, tell us, what do you think about that?
Well, that's a common complaint. And luckily, the good news is it's one that most attorneys are attuned to and they're working to alleviate here as we move further into the 21st century. The bad news, though, is that concerns over accuracy and precision do tend to make legal documents more complicated than everyday language. There basically tends to be a line beyond which, if you move towards further simplification, you're entering into the realm of unacceptable ambiguity. And where that line is can shift depending on the stakes that are involved.
Let's talk about reps and warranties. That's the topic. But give me the big picture. We'll peel the onion back a little bit as we go along.
Sure. For a business purchase, reps and warranties are basically statement of fact that the seller is making about its business and its operation. In a deal agreement, the purchaser will make reps and warranties too, but for present purposes, that's not as important. For example, if you were buying something like a car, you'd want to know that the car runs, how many miles are on it, that the odometer hasn't been tampered with, and that the seller actually owns the car they're trying to sell you. It's not actually their neighbor's car that they've taken for a joyride. So similarly, the same is going to be true with the business. You want to know the financials, that the financials are accurate, that the business is complying with laws, and that the seller actually owns the interest in the business that she's trying to sell you. They're typically very heavily negotiated, but a lot of the business parties don't fully understand the reps and warranties. So it's truly the lawyer's domain. Essentially, you're going to have a couple types of reps and warranties. You're going to have affirmative reps, things that are like, this is true. You're going to have negative reps, except as we tell you otherwise on the disclosure schedules, this is true. You'll also have generally two buckets of reps. You'll have customary or general reps and warranties, and these are things you're going to see in every transaction. And then you'll also have more transaction-specific reps. And in transactions where there's not a simultaneous signing and closing, in other words, you sign and then there's a period before you get to closing, that can happen if you need a shareholder vote or if you need to arrange financing or things like that. You also have closing conditions in which the reps and warranties will have to be true to varying degrees in order for the buyer to actually have to close on the transaction. And if there is a surprise comes up, that may give the buyer an opportunity to walk away from the deal.
Scott, talk about how the reps and warranties reflect the company's relationships. And I'm talking about with its stakeholders, its customers, its employees, landlord, banks, suppliers, those people who make the business what it is.
Absolutely. You're going to have customary reps in every transaction that's going to address all those issues. You're going to have reps about capitalization, who owns the company and how much they own, about key contracts, including those with customers and suppliers, that they're in effect, they're not being breached by either side, and the counterparty hasn't given any kind of indication that they intend to terminate the contract. You also have information about real property, whether it's owned and leased, and about the company's debt.
Wow. Talk to us about, when do you think is the most opportune time for buyers to engage their legal counsel to perform the legal due diligence? And people who follow me know I'm not real big on lawyers handling all the due diligence for buyers, but I'm definitely big on the legal due diligence. When's the opportune time to do it? And should the buyers be phasing in their lawyer in sort of a staggered fashion as the buyer moves through let's say, due diligence and they're getting into financing and deal making, or do we get the lawyer involved fully right up front?
I think you can, the earlier you can get counsel involved on due diligence, the better. In a lot of deals, the lawyers will actually create the diligence request lists in conjunction with your business advisors and help drive the process forward. Overall, though, I think a staggered approach to diligence makes the most sense. And the reason for that is in the event that you have very upfront things raise red flags that are potential deal killers, it's best to examine those first before incurring transaction costs to examine, every little detail of the company. For example, if you do an analysis and it shows that the quality of revenue is dependent on one main customer, and that customer has the right to terminate if the business is sold, that's definitely something you want to investigate early on. And that's an example of how legal diligence impacts the business diligence, because once that issue is identified on the legal side, then the business diligence folks need to sit down with that customer and figure out what indeed is going to happen after the change.
Scott, let me interrupt with you because I want to stay on this topic for a second. A while back, one of the lawyers in my network who specialize in cyber risk, he told me about a deal where about 6 months after the deal was done, the buyer discovered the company he bought, the whole foundation of the company, its strength, its reason for being was an electronic data center. And the software that ran it, it turned out, was unlicensed. The seller did not disclose it to the buyer. The seller was long gone. It's like 6 months later, and the buyer did not detect that in due diligence. Is that the kind of thing that an attorney might have picked up on right at the beginning of due diligence? Because that would have saved this buyer, first of all, a lot of time in deal making. He probably would have aborted the deal. And now 6 months later, you can't unscramble an egg.
No, absolutely. And I think, in general, in every transaction, you're going to have a rep that the seller owns all the IP or has proper licenses for the IP used in the business. And I think you raise a good point that an experienced M&A lawyer that's a generalist or an M&A advisor that's a generalist, we may need to tap in an expert on IP if that's indeed the foundation of the business, but hopefully they would see that issue. And obviously, as you would expect, if you're buying, a company that's a manufacturing plant, most likely IP is going to be less intensive than if you're buying a tech company. And a good, even generalist advisor will see that sensitivity to the business and make sure you get the right experts involved. But yeah, you'd almost always see a rep that it would actually list all the IP and whether they own it or have a license for it.
And that's something the searchers are to be asking the brokers and sellers right up front in due diligence, because if the answer is a maybe, boy, it's a good time to bring that lawyer in, isn't it?
Yeah, absolutely.
Let's carry this a little deeper. We're in due diligence. What can searchers and buyers do to anticipate what is going to influence that contract? I mean, most buyers don't invest in a purchase contract until they know they want to buy a business, but they can spend days, weeks, or months in due diligence. So isn't it smart for us on the buy side to anticipate the kind of things you, the legal counsel, are going to want in the reps and warranties? So even though if you're not fully involved, we can try to ferret out the hot buttons.
Absolutely. And I think you can just look, as a general guideline at any standard agreement and see the reps and warranties and know you're going to want to see things responsive to those reps and warranties if you're a buyer or a seller, that you're going to need to be able to produce those items. But I think the first thing you're looking for in diligence is deal killers. And that doesn't really impact the reps and warranties in the agreement, because if it's a deal killer, you're not going to get to an agreement. But I think that's the first thing, because if there's deal killers there, don't spend the extra time and energy in fully going down the diligence road further. But I think turning to the agreement, you want to look for risks that aren't deal killers, but that they can be mitigated by reps and warranties, and those risks can be addressed and properly allocated among the parties. I think, for both legal and business due diligence, the goal is that basically any kind of fundamental assumptions that are undergirding your investment decision, that those are addressed in the reps and warranties. I think one other important thing is the reps themselves are often used as a diligence tool further along if you're not dealing with the simultaneous signing and closing, because in general, it's important to realize that sellers don't really have any duty to disclose. So by forcing them to make a certain rep, you may prompt a disclosure. In other words, if you have a rep that says there's no pending litigation and they have a lawsuit pending, that's going to hopefully prompt a responsive disclosure that yes, indeed, we have no pending litigation, except this litigation that we're going to describe to you on the disclosure schedules.
Yeah, I like that prompt idea. We've got to be really paying close attention. What would be some of the things that you see going wrong? And I'm talking about during deal making, things that unnecessarily disrupt, or maybe they delayed deals. And I'm talking about the deals that should occur. These deals should happen, but the way let's say the buyer or broker or seller behaves during their communications in due diligence and deal making, all of a sudden the deal gets off track. And then if you can tell us about a couple of the things that you see go wrong, typical. Any successful workarounds you've seen, things that keep deals that should occur so they do occur?
Absolutely. In general, it's important to get advisors involved early. It's really hard to backtrack on deal terms that you've already agreed to, absent surprises in diligence or otherwise. Attempting to do that really decreases your credibility. And you see it a lot that parties don't really realize the full implications of what they're agreeing to sometimes. So be careful with that. And then similar to that, if you do have advisors, listen to them. You don't always have to agree, but definitely you're paying them for their insights. So consider what they're saying. I think the next one is probably my biggest tip for both the actual parties and their advisors. It's super important to be reasonable. Now, in certain situations, for sure, there are take it or leave it deal points that you're just unwilling to yield on. And that's fine and appropriate in some cases, but you can't have the view that every single term in the agreement or in the deal is a take it or leave it issue. Basically what I tell people, and sometimes this doesn't make them happy to hear, but almost every deal that gets done leaves both of the sides a little uncomfortable about something. And I think finally, it's important to know your bargaining power. If you needed to sell your business yesterday, you have less than if you can run a 3-year process to find the perfect buyer. Similarly, if you're one potential purchaser for the business, you have more bargaining power than if you're one among 3. And so I think that's important to keep that in mind and be realistic about it.
Picking up on that thought, one of the things I tell the buyers who hire me or even talk to me is there are no perfect businesses. And if you're looking for them, good luck. Buying a business is all about risk management. There is risk. And what we're trying to balance against it is what's our return? Hey, what about reps and warranties insurance? I've been reading magazine articles about that.
Sure. Reps and warranties insurance, RWI, is basically an insurance product that can allocate the risk for the breach of reps and warranties to an insurance company. They can either be in favor of the buyer or the seller. And you're absolutely right. You probably are reading about it. It's becoming an extremely popular product, especially filtering down to the lower middle market. So we're talking about deals typically for companies between $5 and $50 million in revenue. So what that means is it's still not very common in the small and medium business transactions, just because of all the diligence work the insurance company has to do to underwrite the RWI product. So we're just not seeing it quite yet, more for the Main Street businesses.
Scott, one of the things that's interesting to me on this reps and warranties insurance, I do business worldwide in places like Australia and all through the UK, and Canada, depending on what country you're in. Some places it's more readily available than others. And in one of the countries I talked to just a couple of weeks ago, they'd never heard of it. No insurance carriers are there even thinking about offering it. Okay, new topic. Let's talk about the kinds of deal terms that can make or break deals. The kind of provisions that go in the purchase and sale agreements, and particularly those that tend to be the most arguable. When should the buyer or the searcher introduce the topic to the seller or the broker? So maybe it's not exactly at contract time, but we know that most of the time this is what's going to be a problem with sellers and brokers. What are some of the deal terms that they're not necessarily red flags, but they scare people and they require a whole lot of negotiation?
Sure. It's basically what you would expect. The key business and legal points for the deal things like the purchase price. And obviously, if you're talking about timing, you may need to do a certain amount of diligence before you get to a purchase price. So that may not be, upfront. That may be more when you get to the term sheet stage. Another big one that you always need to consider, and I think a lot of times sellers are more conscious of this than buyers for obvious reasons, but the payment terms of that purchase price. It's not just the number, but it's how it's going to be paid. Is it going to be cash at closing? Is there going to be seller financing with the down payment? What are the percentages for those? Are you going to have a financing closing condition? Things like that. Along with that's going to be the deal structure. Whether you're going to do an asset or stock deal, there's legal implications there for sure, but also huge tax implications. And unfortunately, the deal structure tends to be one of those things that's zero sum. There's no real middle ground as far as the tax implications go. So you definitely want your tax advisor involved on that and to advise you, but that tends to be a big deal. Sort of similarly in an asset deal, the purchase price allocation, you'll have things like lease assignments. That's a big deal because a lot of times, the continuity of the business depends on the continuity of the location in certain instances. So you want to make sure you can get a lease in place. Non-competes and non-solicits with the former owner. And one thing to note, if you happen to be in a state like I am, California, that does not enforce non-competes in the employment context, note that that has nothing to do with the business sale. It's a very different situation. So just because your state won't enforce it for a non-compete against a former employee does not mean that same non-compete won't be enforceable in the context of selling your business. So those are a lot of the main points. And typically those things will get nailed down in greater and greater specificity as you move from an indication of interest to an LOI or term sheet to the definitive deal documents. And I think as far as timings goes, as a purchaser or a seller, if they're make or break terms, it's best to raise them as early as possible to avoid spending time and resources on a deal that's just not going to happen from your perspective.
One of the things that impedes deals that I've been involved in a lot, remember I work for buyers, hired gun for buyers, is the personal guarantee. Sellers want a personal guarantee. They want it to be a blanket. They want it to be forever. What about that? Is that one of those things that, in fact, in terms of timing, we've had deals fall apart because a buyer up front or a searcher up front says, hey, I'll never do a personal guarantee. Well, brokers and sellers usually tell them to go pound sand. On the other hand, if they don't somehow begin to work towards some common ground on that, they may find out after they've paid thousands of dollars for a purchase contract when the seller says personal guarantee only.
Sure, and that's a common thing, and I think that's an advisor role to a degree, that if you're representing a potential purchaser, you need to make them understand that unless they already have an operating company that's going to be the party signing on the line that has significant assets that can back up the acquisition, that any reasonable seller is going to want to expect that personal guarantee. I mean, you're not going to sell somebody your business and potentially have them have their newly formed LLC with no assets on the line for, a $5 million purchase price debt. So it's totally reasonable. And I think a lot of that has to do with socialization from the buyer's counsel, just buyer's counsel and advisors, that's a totally normal part of the process. But yeah, for sure, you can expect, you can negotiate. Where the negotiation should occur is not blanketly whether there is one or not, but it's around the terms. How long does it last? What all is the collateral for the guarantee? Information rights. Do we automatically get all the buyer's personal finances, or do we only get personal finances if there's been a breach or a late payment, things like that?
Listeners, a while back, an organization that trains CPA firms, particularly those that are involved in M&A, they shared with me a 12-point negotiating guide they use when they're representing any side that's being asked to provide a personal guarantee. And it is really street smart stuff. So if you contact me, I'll be able to share that with you. And it's something you can use to try to negotiate better terms when you are going to have a personal guarantee. And sometimes, if you carefully read the tactics, you can make it go away. Okay, let's talk about now USA. United States of America. Let's talk about UCC. That's the Uniform Commercial Code. I'd like you to define it, Scott. I'd like you to talk about its necessity. Now, for those of you in Canada and Australia, New Zealand, UK, I don't know, you may have something like that. This is sort of unique to the United States. Go, UCC.
Sure. So the UCC is basically a body of contract law that governs the sale of goods. So if I'm a coat manufacturer and Ted, you're a store that orders coats, and we are conversing about you potentially buying coats, the UCC will govern that transaction rather than common law contract law. That's the legal background. And as part of the UCC, you have both express warranties and implied warranties. So some of the implied warranties that you'll see is that the product is suitable for its intended use and merchantability. That means if you're ordering coats, absent, a disclaimer, otherwise the assumptions is going to be that the coats are designed to keep people warm and they perform adequately, whatever that means at that purpose. So I think, it's a great question in this context, Ted, because a lot of people, even lawyers, don't really consider how the UCC applies to M&A transactions, but they really should. I mean, obviously at the outset, the first thing to analyze is if the UCC applies. So if there is a sale of goods. So obviously, a prime candidate for this would be any kind of retail type situation or even wholesale situation where you've got inventory that you're selling to customers. If it does apply, the thing that you want to do is absolutely make sure you include those UCC endorsed specific disclaimers that you're disclaiming those implied warranties. That's very important. And this goes to another point. As a seller in a business, you're always going to have one of the final reps that you'll make, or the final statement in your section of reps, is that there are no other reps that are other than those that are included in the agreement. But for UCC purposes, you want to go a little bit further than that in the language.
Okay, listeners, particularly you searchers, this is one of those things very early in due diligence you ought to touch base with your legal counsel on. Okay, new topic. I read an article, I think we all know this, that something like 70% of transactions, I'm talking about M&A transactions, do not meet the party's expectations. And the bad news is the cost to cure. In other words, those things that went wrong that you didn't think would go wrong, the cost to cure can far exceed the recovery. So what are some of the most prevalent or maybe costly things that do go wrong after closing of a transaction? I'm talking about the breaches. And give us a hint. What's the reality for the aggrieved party to adequately cure the breach?
Sure, absolutely. From the legal side, I think the two probably biggest areas you're going to see are disputes over working capital adjustments and earnouts. Those disputes can be minimized by using very specific language in the agreement, and then also having some sort of cost-effective resolution mechanism. Now, whatever cost-effective means depends on the size of the deal, but in most small and medium business transactions, one good solution is having arbitration. But something a lot of people don't know is that a lawyer or a former judge doesn't necessarily need to be your arbitrator. For instance, an independent third-party accounting firm could be your arbitrator. And if you let an independent third-party accounting firm be your arbitrator and resolve either an earn-out dispute or a working capital adjustment, that may be a lot more effective way than going to arbitration and certainly litigation. Another issue you see is issues with customers, specifically having your customer base sort of erode after you take over the business, perhaps because some of these key customers had a personal relationship with the seller. And that's something that's more of a business issue, but that's something that really needs to be investigated during the diligence process. Turning back to the legal side, tax, environmental, and benefit type issues, a lot of those tend to be strict liability, meaning the new owner is going to be on the hook no matter what. So you need to make sure your reps on those fronts are super solid. Also, any kind of non-compete, non-solicitation issues with the former owner. And in general, I think it's a huge red flag if the former owner is pushing back during the negotiation process really aggressively on that. That's just a bad sign. I mean, basically, if your owner is going to sell the business, he or she should be able to commit that for a reasonable period of time, they're not going to compete with you in your immediate geography.
Boy, anything else on that?
No, I think those are the main things. And again, on the business side, you see lots of other things. Your business advisors can tell you that taking over a business and immediately implement changes tends to be a bad idea, that you should spend some time probably running the business as the former owner did, before you start correcting what you perceive as mistakes. That's a big one. But I think really the tax and environmental, as far as on the legal for strict liability, you have to be careful about.
Let's say the deal is looks like it's going to be done. Help us understand, what are post-closing covenants?
Sure. Yeah, it's important to distinguish the reps and warranties from post-closing covenants. So post-closing covenants are promises that the seller is making. In this context, we'll focus on the seller, that the seller is making to the buyer about the seller's actions after closing. So some of the big ones that we already touched on will be the restrictive covenants. That includes like a non-compete, that typically that the seller will not compete in your area for a certain amount of time, as far as certain business loans, which hopefully is your whole business. A non-solicit, this means that the seller won't try to poach your employees, which maybe potentially were his employees or contractors. And then another one that you often see is that sometimes that the seller will not poach or solicit customers of the business, because the last thing you want to do is buy a business and then find out that the seller's been dealing behind your back to take all the customers with him. And the next one that you'll always see is like a further assurances covenant. And that basically means that the seller will take steps essentially to fulfill the transaction. In other words, if there are agreements that haven't been assigned yet and things like that, the seller will do that post-closing, to help you out with just fulfilling the spirit of the transaction. And another one you often see, this is most of the time not handled in the actual acquisition agreement, but it's actually the seller's ability to provide you with consulting services for a limited period. And so usually that's some sort of contract or agreement that you would sign that'll basically say the seller will be available to help you for a period if questions come up.
Okay, I only have about 2 more questions. But this is pretty important. Let's focus a little more on the pushback. And what I'm thinking about are those post-closing covenants and the reps and warranties. Remember, I'm working for buyers. What are the seller's legal counsel going to want to push back on, and the things the buyer wants to see in the reps and warranties or in those post-closing covenants? Just sort of the big picture there on that pushback.
Yeah, for sure. I think to back up, unfortunately, we're going to get into some legal weeds here, but the use of both the word knowledge and materiality qualifiers needs to be appropriate, and both sides are going to fight on that. And for example, materiality is just a word that lawyers say that basically means significant. So you can say, here are all our contracts, or you can say, this is a list of all our material contracts. Obviously, the more you make it broadly applicable and don't limit yourself to materiality, that favors the buyer. The more you limit things to materiality, that plays in favor of the seller. Similarly with knowledge, typically, you'll have a bunch of reps that say, to the seller's knowledge, there's no threatened or pending litigation. You use that more for threatened rather than pending litigation. And knowledge can be defined in different ways. It can be the actual knowledge of the seller. That sounds reasonable, right? Well, that obviously favors an ignorant seller to the degree that the seller makes sure that he or she knows nothing about his or her own business. Then they can make that rep all day because they don't know. Usually, instead, you end up with a constructive knowledge standard, which sort of means that basically it's the seller's actual knowledge and the knowledge the seller had if he or she exercised reasonable due diligence. So you'll see a lot of the play on the customary reps is in those qualifiers and the knowledge definition, because by and large, the customary reps don't tend to be that arguable if you basically keep them reasonable. Second, I think you'll find more arguments over transaction-specific reps, as you would expect. For instance, if there is pending litigation, to allocate risk, you may say, hey, you're going to make the rep that there's no pending litigation where damages are reasonably expected to be more than, make your number up, $25,000. And that's definitely a risk allocation, because what you're saying there is if that litigation settles for $100,000, then the seller's going to be on the hook for that $75,000. So that's where you see more back and forth. Also on things like in environmental reps, because environmental liability tends to be strict liability. So obviously those reps are going to be a lot more important, like if you're purchasing a chain of gas stations or dry cleaners, than if you're buying a software company. And, you know, there's other issues here too, like survival periods. Oftentimes reps will have different survival periods. So typically for those strict liability things like tax and environmental, you may have them survive to the statute of limitations. That's what I would want representing the buyer. Obviously the seller's going to push back. Also for other what we call fundamental reps, like you own these shares that you're selling, that should survive basically indefinitely. But some of the other reps, like the financials, will survive less. And I think finally, when you're looking at the reps and warranties too, you want to think about who's making the rep, whether it's the entity, whether it's the owner, whether it's the officers, whether it's all of those, and if they actually have access to the relevant information.
Wow. Wow, that's something, listeners, I would, in fact, I will, when I listen to this podcast, I'm coming back and listening to that. It's right towards the end. And speaking of the end, here's the last question. Talk to us, Scott. Do you have any thoughts on just related to the pandemic and the financial crisis that we're all coping with? And just keep it with, contained within the reps and warranties and post-closing covenants.
Sure. I think for reps and warranties, obviously certain things are going to change. Like typically in a financial rep, you're going to provide your interim balance sheet as of 3 months ago. In the C19 world, that makes no sense. I'm not going to say you need a balance sheet from a week ago, but you need the most current interim financials possible. I think one thing that we're seeing a lot of uncertainty around, and hopefully the uncertainty will be removed by government action, but that PPP or other government program money, is that ultimately going to be an asset or a liability of the business? And so you're going to need a way to disclose that, and also have a way to adjust for that money in case you initially put it in the wrong bucket. And I think finally, not related directly to reps and warranties, but there's going to be a lot of valuation differences depending on different economic outlooks that buyers and sellers are going to have. Understandably, buyers are going to be more pessimistic as to the company's performance going forward, and sellers are going to be more optimistic. So you may see lots of contingent consideration structures, things such as earnouts and things like that going forward in order to help bridge valuation gaps.
Wow. Thank you, Scott. Scott Weavil. Folks, check out Scott's LinkedIn profile. I think you're going to be as impressed as I am with his professional history and what he's doing today. So Scott, what's a quick and easy way for people to get in touch with you?
Sure, thanks, Ted. You can visit my website. It's Weavil Law, WEAVILLAW.com, or you can email us at contact@weavillaw.com.
Okay, folks, here are 2 more resources, and they're helping people who are on the deal-making playing field right now. Guess what? 2 of my books. The first one for searchers, How to Prepare Yourself and Find the Right Business to Buy. And if you've already found a business, when you get to due diligence and deal making, how about this one? How to Buy the Right Business the Right Way. You will save time, you will save money, you'll achieve better deals, but you have to do what the savviest buyers do. I'm available to help you deploy the tactics and the strategies from my books. You can get them at my website, partneroncall.com. So I'm Ted Leverette, the original business buyer advocate with Partner On Call Network, wishing you prosperity and safety. Thanks for listening.